Okay, 11 o'clock, time to start again. Welcome back, guys. Let's get busy. We're talking about the broker-salesperson relationship and independent contractor status. We talked about responsibilities. We talked about pay. Did anybody have any basic questions about this discussion before we move on? Not seeing any, then let's move on. Broker's compensation. When does your broker get paid, and how is he paid, and how do they charge, and how's the fees, and what's the rules? Well, here's the thing. Your broker will discuss with you what he wants you to get for commissions when getting listings for sale. You're going to work with buyers. You're going to work with sellers. When you work with sellers, you have to tell them what you're worth. So, how do you know how much you're worth? Your broker's going to tell you. He's going to say, I want you to get a 6-month listing with a 6% commission. Now, your job is to go out and convince a seller to pay you 6% for selling your house, and you got to get a 6-month listing to do it. So, in effect, your broker sets the policy, you carry out his policy, and the client may object or agree. If they object, then you have to go back to your broker and say, he doesn't want to pay 6%. What do I do? Well, he needs to train you on how to justify your commissions and how to negotiate to get your best commission rate. Either way, the negotiation is between you and the client, but in effect, it's between the broker and the client. Remember, the broker is the authorizing entity. He sets the policy and procedure. He sets the amount of commission he's willing to accept, not the salesperson. Whether he charges a percentage of the sales price or a flat fee is up to your broker to decide. There's no rule that says it must be a flat fee. There's no rule that says it must be a certain percentage. There's no guideline that says this is the amount of money you must charge to sell a house. There's no association that says this is the amount of commission you must charge. There's no national entity. There's no state entity. There's no regional, county, or municipal agency that says you must charge X amount of dollars or percentage to sell the property. It's whatever you and the client negotiate. Because once again, I'll reiterate, in New Jersey, all commissions are negotiable. So once you do get a listing out of a negotiated price, well, then that's what your broker earns for completing the job. In order to complete the job, you must have a ready, willing, and able seller and a ready, willing, and able buyer come to terms and conditions and agree to a sales contract. Now, when we negotiate between buyer and seller, it depends on who you work for. If you're a buyer's agent, you're trying to get the buyer the best price. If you're the seller's agent, you're trying to get the seller the best price. Whatever the agreed upon contract is must be solidified in a written format, a sales contract. Once buyer and sellers sign an agreement in the contract, then you have established something called a meeting of the minds. In other words, I have this house for sale and I'm advertising it. A buyer comes along, wants to buy it. We negotiate with the seller. We negotiate a sales price and we sign a contract. When we sign a contract, it is called the meeting of the minds. It's where an offer and acceptance of that offer has occurred. Whether there's negotiation back and forth, sometimes yes, sometimes that occurs. But eventually, so we agree to a price, terms, and condition. We sign a contract. A meeting of the minds has occurred. Now, please listen, because I don't want to have to repeat this 17 times. When we have a buyer and seller both agree to price, terms, and conditions and sign a contract, and a meeting of the minds has occurred, it is at that moment that a broker is said to have earned their commission. It is that moment that the broker is said to have earned the commission. However, he doesn't get paid at that moment. We earn our money by putting deals together. We get paid when deals close. So maybe, let's say you're a phenom and you go to work for a broker and, geez, in 2 weeks you got a house that's sold. And what? You sold the house? Well, it's not sold until it actually closes, but you agreed to price, terms, and conditions, sign a contract. You had a meeting of the minds. According to the laws of agency, at the moment a meeting of the minds occurs, it is said that brokers have earned their commission. So in 2 weeks, you earned a commission, but it may be 3 months. It may be 6 months. It may be 120 days. It could be a year later before the deal closes, which means that money you earned is just that, earned and not collected yet. Brokers get paid at closing. That's when the broker gets paid for doing the job. 10 days after the broker gets paid, he must pay the agent who was the procuring cause of the sale. Now I'm going to come back to a couple terms here in a minute. So in effect, let me use a whiteboard, see if I can transfer this into a timeline. Here's let's say the 5th. Okay, so you're in the licensing class. Let's say by 1:30, you're licensed. You passed the state exam. You activated your license with a broker. So the timeline's going across. And on 2/10, you sold the property. It's now under contract. That's the meeting of the minds. That's MOM, the meeting of the minds. On 2/10, you agreed to contract, price, terms, and conditions. However, it may be 5/15 when you close. That's 3 months later. That's when your broker gets paid on the closing. So you have earned the commission when you had a buyer and seller agree to price, terms, and conditions, sign a contract, but you get paid when the deal closes. And then within 10 days, 5/25, you get paid. So the broker gets paid at closing. 10 days later, you get paid. Now, that's on a relatively simple residential transaction. I've worked on commercial deals that took literally years to put together and years to get paid. I have a very good friend whose name is Darren Lizak. He's one of the managing brokers at NAI James Hansen up here in Paramus. He told me a story. He worked in a deal. He started it and completed a deal when it closed 9 years later. That's how the way sometimes commercial deals go. However, that one payout he received at closing was like 2 to 3 years worth of income at a good income rate. So commercial dealers are used to waiting a long time to get paid. Residential brokers usually get paid 2 to 3 months later because the deals usually don't go much longer than 2 or 3 months. Sometimes they go longer, not much longer than 6 months. So remember, if you were successful and get your sale out the door in February, it may be May or June before you actually get paid on the deal, just so you know. So the procuring cause is something I mentioned before. What's that? Procuring cause is a thing that leads to a chain of events that leads to a closing. So if I'm the buyer's agent and I introduce a buyer to a property and we negotiate a price that the seller is willing to accept and the seller signs a contract and the buyer signs a contract, it would be known then that I am the procuring cause of that sale. However, Procuring cause of a sale is sometimes very hard to determine. And let me explain why. I was called to a tribunal hearing as a broker in a local board office. As a neutral third-party broker, I was asked to come in with two other brokers who would be neutral to the hearing. It was a contested commission dispute between two brokers. Now, by the way, when you join a board of realtors, you agree to binding arbitration at the board level between companies. It's a requirement that you're going to have to agree to. So we heard the case where one broker said, I am a procuring cause of a sale, but my client was stolen from me and someone else closed the deal and took the commission. I'm complaining that I should be paid that commission instead. Well, we wanted to hear this case. So, Ms. Broker, please explain what you mean. Well, here's the paperwork. I started with these folks on X date as attested by the consumer information statement. Remember, I told you about that yesterday. So there's a consumer information statement. Then, working with a mortgage broker, we got them qualified and actually approved with a mortgage to buy a house of such caliber. So through my efforts, we got them approved with a mortgage. Then I took them out and showed them different houses. In fact, I have the printouts of the lock boxes showing when I showed certain houses, and the times correspond with the buyers with me seeing that house. So I can prove that I introduced the buyers to that house that they eventually bought. But the day after that, the buyers disappeared and wouldn't return my calls. The next thing I know, the house that I had shown them is under contract. And when I called the broker and asked, they actually gave me the information, not supposed to, but they gave me the information of who the buyer was. Turns out it's the buyer I introduced to the property. Therefore, I'm claiming that I'm due a commission. I was procuring cause. Okay. Second broker, let's hear your story. Well, we don't know who this other agent is. We don't even care. All we know is that a person came to us, said they had a need. We negotiated the sales price of the property and had the contract signed, and they bought the house. We are procuring cause, and that's the end of the story. So you can forget about that other broker. We're not paying them. Okay, interesting. So we had a few questions, and as you know, if you have kids, there's always at least three different sides to every story. There's one party, the other party, and then there's the truth somewhere. So to get to the root of the cause, we asked the first broker, would you mind if we called up those buyers to confirm your information? No, not at all. You can call them. We asked the second broker, would you mind if we called the buyer and confirm? No, I don't want you to call them. Their privacy is utmost important there, and they would expect that you would respect that. Well, we had permission from the first broker, so we called. And this is what the buyers told us. Yes, the first broker, everything she said is absolutely true. We started our journey with her to find a house. She qualified us, got us in with a mortgage broker. The mortgage broker approved us for a mortgage. She took us out, showed us houses, very patient, very understanding, and showed us a house that we actually bought. However, right after seeing that house, we found out that one of our best friend's daughter just got her real estate license. So we figured we'd give the deal to her. So we showed up at her office and told her about the house. She said, I'm familiar with that house. She wrote up the offer and then went and negotiated it for us, and we got the deal. We closed on the transaction and our realtor got paid. Okay, thank you very much. So now we get the full story of what happened. The first agent did absolutely nothing wrong. In fact, she did everything right. From the consumer information to the mortgage application to recording information about showing houses, et cetera, she did everything right. The second agent, though, we had some follow-up questions. We asked the second agent this. When they came to you, did you give them a consumer information statement? No, it was already given by the other broker and it wasn't necessary. So you knew that they were working with another broker? Well, they had said they had met with another broker. Did you ask if they were working with the other broker? No. Don't you think that would have been important to know? No. They didn't volunteer the information. I didn't ask. Okay, so you don't have a consumer information statement. You didn't ask if they had an interest in or had a agency relationship with another broker. When did you show the property in question to them? I didn't have to. They already saw the property. All I did was write up the offer and negotiate it, of which I won the negotiation and my clients bought the property. I'm deserving of the credit of their commission. Well, we have some questions. Since you didn't show the property to the buyers, who in your office did? No one. Well, how can you be procuring cause if you never discussed agency relationships, never inquired about any other agency relationships, never showed the property, did absolutely no work except to negotiate an offer? Is that correct? That's all I had to do. Well, here's the problem. No, that's not. Number one, whenever you meet a buyer, guys, here's the questions you have to ask. Are you working with any other agents? If they say yes, then you have a follow-up question. Did you sign any buyer's agency agreements with them? If they say yes, then your immediate response is to say, sorry, I can't work with you. What? No, I'm being very serious here. One of our code of ethics requirements state that realtors shall not infringe on the agency relationship that a person has with another company. And because you didn't ask the question, which you should have, you didn't know about that. If you had realized that, you would have not proceeded in your search or helping them find a house, would you? Well, I don't know about that. Well, technically, that's what you're supposed to do. Besides, what profit would you have gained if they had an agency relationship with another broker and then you interjected yourself in between that? That would have put you at a disadvantage. So now we know why you didn't ask the questions, because you didn't want to deal with the consequences. Secondly, you never showed the house to the buyers. So to be entitled to a commission, you must have shown a property to the buyer. I didn't have to. They already saw another broker. But you weren't the procuring cause that created this chain of events, were you? No. Our decision is this. We would split the commission between both brokers because we feel the first broker had procuring cause and should be entitled to the commission, but we also understand that you put in some time and effort negotiating, etc. The second broker who sold the house said, we object. We don't agree with your decision. Since you don't agree with it, please remind yourself that you're under binding arbitration. If you reject this offer, we have no other room to go except to award the full commission to the other broker, which we did. Now the broker's pissed. Well, guess what? Procuring cause is sometimes very nebulous. You can't see it right away. You don't know where it is, what it was. So we have to do some fact finding. Procuring cause is sometimes hard to determine, but when we find out who has procuring cause, show us the events that led up to this thing to prove that you had procuring cause. And if you can prove that, commission's yours. The second broker made the very poor decision of not asking questions. She was a brand new agent and was handed this deal by the buyers. The buyers did nothing wrong. Buyers are not responsible for agency behavior, but the agent should have known better. Even though she was new, she should have known better. Her broker did not train her properly, and the broker should be at fault as well. After they rejected our settlement, we just told them, forget it then. We'll just award everything to the other broker. And she got mad, and you know what? Too bad. That's the way it is. So guys, understand. Keep very good records of what you do with whoever it is you do it with. Always keep a timeline with everyone. And prove what you do by recording dates, paperwork, information or lockbox readouts. You can record all this stuff and keep it as record. So if there's ever a question, your proven timeline is going to supersede anybody who said, well, I think they showed up on a certain date. So please do yourself a very big favor and keep very good records. So that there is a commission dispute, you can prove procuring cause in a handy timeline that you can hand right over to the investigators. So whoever is the procuring cause is entitled to the commission, not the people who step in at some other time and try to rob it from them. So any question or discussion about this before I move on? If the client didn't like the first broker and wants to discontinue with the first broker, what does the client do to be able to work with the second broker on the same house if the first broker already showed them the house? Well, if they have an agency relationship, they have to have it discontinued. They have to have it nullified. Then the other agent who takes over, the next agent, has to actually go and do everything over again. Are you qualified? Did you get a mortgage approval? Did you sign a statement? Can I please show you the house again over again to prove that I'm doing everything right? That's what they're going to have to do. But first, they have to get that agency agreement dismissed. And that's not easy to do. Right now, do you discontinue the agreement? What if the mortgage was applied? I'm sorry, David. I'm not understanding the context what you're asking. What do you mean, right now, do you discontinue the agreement? I don't understand what that means. And I don't know how a mortgage, if it was applied for, relates to this. I'm sorry, unless you can put it in a sentence that I can understand, I'm not able to answer that question. All right, guys, I do need to move on. I'm sorry, but how do you discontinue an agreement? Wait till it expires or get yourself an attorney to get you out of it. I need to move on, guys. I'm sorry, but we really do have to. Salesperson's compensation. Now, remember, your employment agreement, your independent contractor agreement with a broker is going to specify your commission split that you're going to earn. So if you sign a contract, let's say you sign as a 50-50 split. If your broker has, if your deal closes on today, it's the 5th of January, then your broker has 10 days in which to pay your split. So within 10 days, he'll be cutting you a check. If you earn 20 grand, he's going to cut you a check for 10 grand. 50-50. Now, you better make sure in your employment agreement, your independent contractor agreement, about what fees you have to pay for, because with many big box companies, you have to pay a franchise fee, there's advertising fees, marketing fees, there are MLS fees, there's all kinds of fees. My son's, new Jeep fee and all kinds of stuff. I'm kidding. So when you get your paycheck, then you have to account for taxes, expenses, income, bills, et cetera, but you're paid within 10 days after the broker is paid. If you work for a broker who doesn't pay you in the allotted time frame, number one, report them to the real estate commission, because no broker should be taking advantage of salespeople. And if they do, they shouldn't be in business. I actually shut a broker down that I was working for. He was a New York broker, opened up a shop in Jersey, wanted somebody to manage it. I said, me. When we closed on our first transaction, I expected my cut of the deal within 10 days, and 11, 12 days later, I called him up. I said, hey, where's my cut? He goes, what are you talking about? I said, of the commission. He goes, you're not getting anything. I go, what are you talking about? Oh, I had other bills I had to pay. No, you don't. Your duty as a broker is to pay your salespeople their money within the 10 days that's required by law. I reported him to the real estate commission. They said he's not worthy of holding a real estate license. They sent me the paperwork as an affidavit to shut down the office, of which I did, naming his attorney as the record keeper and trust account keeper of all records. And I left his employment, and his company shut down. You can't mistreat your salespeople, guys. The real estate commission is very serious about this. If your broker tries to rob you of your commission, he's not going to be in business very long, because you have the right to collect your commission in the agreement that he signed with you within 10 days of him being paid. All right, so creating agency with buyers and sellers. Well, we can do it with a written statement. I'm hiring you to sell my house through a listing agreement. Or I'm hiring you to help me buy a house through an exclusive buyer's agency agreement. So there's going to be a form that you're going to use. I'm going to use a listing agreement for sellers and a buyer's agency agreement for buyers. If they sign my agreements, then I'm employed and I'm going to work to earn a paycheck. You're going to work very, very hard to get a listing, but once you get a listing, then you have to work very, very hard to get it sold. But you're always working to get a contract, whether it's a seller or with a buyer. You're always working to get those contracts because that's when you actually go to work. So an agency agreement can be created by signing these documents. A seller would sign a listing agreement, authorize me to list their home, advertise it, and collect a fee when we successfully market it. A buyer's agency agreement authorizes me to work as the buyer's agent to help them find a house. Now, something you may not know. First of all, on page 34 through 41 rather, I'm sorry, through 39, 38. 34 through 38 is the independent contractor agreement most brokers would use as a boilerplate. In that independent contractor agreement covers all the requirements that a broker and a salesperson must agree to. On page 40 is a sample exclusive buyer's agency agreement, which creates a buyer's agency relationship with a broker and a buyer. Now, if you would please, on page 40 in your 14th edition textbook, look down to paragraph number 5 where it says brokerage fee. And I want you to read that paragraph because I have a question for you when you're done. So start reading that paragraph. Page 40, paragraph 5, which says brokerage fee. Please read that. And when you're done, I have a question. Go ahead. So now that you've read this paragraph, my question to you is this. Who pays the buyer's agent their fee? Anybody? Who pays the buyer's agent their fee? Well, the buyer's agent is the broker. So buyer, seller, buyer, the buyer, broker, that doesn't mean anything. Seller pays all, the buyer, agent, broker. Okay, you guys are mixing terms up. The agent is the broker, guys. Who pays the broker? The buyer's broker. Who pays the buyer's broker? So everybody's saying the broker, but it's who? The buyer's broker. Okay, we're missing the point here. Let me moderate this conversation real quick. Remember, according to laws of agency, the agent to the client is the broker. The salesperson is a sub-agent. So who pays the buyer's agent? Who pays the buyer's broker is the question. According to the statement, who pays it? Seller, the client, the buyer. Okay. So apparently nobody really is sure about who pays this. The agent can't pay himself, Andrew. It doesn't make sense. So let me moderate here real quick. The seller's broker, says Michelle. Ding, ding, ding. Thank you. I see Ranit, you also said seller's broker. That's correct. What it says is this. Where the buyer's broker sells the property to the buyer, normally the seller, through the listing broker, the selling broker, pays the buyer's broker for their split of commission. Now, through the multiple listing service, when I list a property, I agree to co-broke with my other fellow brokers the deal, let them know about it, and give them a co-broke fee. Therefore, if they produce the buyer, my seller pays me my full amount of commission. I share that with the buyer's broker. So therefore, in effect, the seller's broker pays the buyer's broker to bring the buyer to sell the house. That's correct. However, it goes on to say this. In the case where the seller's broker does not pay the fee, then what does it say? It says then the buyer must pay it. What? Yes, it says the buyer must pay. So here's the problem. Hi, come on in. Hi, my name's Tim Jensen. I'm the managing broker of XYZ Real Estate. How can I help you today? I'm looking to buy a house. Terrific. Let's go buy a house. So we find a house and we buy it. And in the agreement, it says that the seller's broker pays my fee because I'm the buyer's broker. And at closing, I get a check from either the seller or the seller's broker for my fee, my split, and everything's cool. But what if I'm showing a house and the seller's not, or the seller's broker's not offering a co-broke fee? There's zero co-broke fee. How am I going to get paid? Well, in this case, the buyer's agency agreement says the buyer pays that. So, Mr. Buyer, you owe me 3% or whatever is the agency agreement has specified as the commission. That's how you got to pay me. But that's not fair to the buyer, is it? No, it's perfectly fair if they sign the agreement. So here's the thing. When people come in my office, hi, I'd like to buy a house. Yes. Are you working with any other brokers? Yes. 3 of them. Okay, fair enough. Have you signed any paperwork or agency agreements with those brokers? I signed 2 of them with 2 brokers. Okay, great. So thanks for coming in, but I don't think I can help you. Have a nice day. What? Don't you want to help me buy a house? I can't. Why not? Because you have an agency agreement with another broker. So I'm not allowed to infringe on another broker's agency relationship with their buyer. Well, I don't like my broker, but you're under agency agreement. Well, how do I get out of that? You have to wait till it expires. How long do you have? Oh, 6 months? Well, you got to wait till the end of 6 months before you can come back to me and I'll help you buy a house. But I don't want to wait 6 months. I want to buy a house now. But you're under obligation to a broker for that period of time. I want to get out of it. Then you better hire an attorney to see if he can get you out of it. Other than that, you're stuck. I'm sorry to say I can't help you. Thanks for coming in. Have a nice day. And believe it or not, that's a conversation I've had too many times, and I hate those conversations because I'd love to sell this guy a house, but I want to be paid for my services. So here's the problem, Mr. Buyer. Let's say I do sell you a house. Your agency agreement for a specific period of time in a specific area states that if you buy a house in that period of time in that area, then normally that broker is going to get paid by the seller. Since you bought it through me, they're not getting paid. Therefore, you got to pay them. And since you signed 2 agency agreements, you got 2 broker commissions you're going to have to pay if I sell you a house tonight. How do you feel about that? That's unfair. No, it's perfectly fair. Guys, understand something. People sign contracts just because they want to see a house. Well, that's awfully irresponsible of anyone to do. So the guy now sues me for unfair business practices. And in court, the judge asked him, Mr. Buyer, is that your signature on the contract? Yes. Well, what do you have to say for yourself? But I didn't know what was in the contract. That doesn't work in court, guys. It doesn't work. Ignorance is not part of the law system. Ignorance is no excuse to commit a contract error. It specifically says if the seller's agent doesn't pay, then the buyers get paid by the buyer's agent gets paid by the buyer. So sorry, but you have to pay your buyer's agent the commission, even though you bought it through someone else. Yes, this is true. So be very careful. To me personally, now, I'm not you and you're not me. And you're going to have to find your own way to work through this with your broker. But personally, I never use buyer's agency agreements. Never. I was able to establish relationships of trust and mutual respect. I didn't have to worry about that. But if you have a snake as a client, you better get them in paper to sign a contract agreement, or else you might do all kinds of work and not get paid for it. So understand, guys, agency relationships are very important. Listing agent gets a listing agreement signed. That means the seller can't go to any other broker to have them sell their house. They can only go through the authorized listing agency. A buyer's agent's one signing an agency agreement with a buyer. That buyer is now obligated to work with that agent until it expires, or until an attorney can get them out of the contract agreement. So understand, contracts are ways to make money, so you better know your way around contracts. All right, let's move on. Now, yesterday I mentioned, and today I'm mentioning again, the Consumer Information Statement. The CIS form is nothing less and nothing more than an information statement. It starts on page 43 and goes to page 44 in your 14th edition hardcover book. And it explains the 4 different agency relationships that consumers can have with real estate brokers. So, I'm sorry, let's pause because Charles Harmon has a question. Apparently he's been typing for a while. Charles, what's the question? You mean we stopped our conversation because, or do you have a question, Charles? Guys, please, let's not do this. I mean, I'm stopping a class to ask a question and you don't have a question. I mean, that's not very conscientious of the other students. Ayana, I'm confused about the seller broker. Why is the seller broker paying? I'm confused. Oh, same question again. I have a question. Gee, I think you have a question, huh? So let's see. I'm confused about the seller broker. Why is the seller broker paying? Because that's how it works. Let me explain with a whiteboard. I'm going to moderate here. So, broker A is the listing broker. He gets the listing. Broker B is the buyer's broker. He has the buyer. So this is a seller, this is a buyer. Now, when that seller lists with this broker, he's authorizing that broker to sell the property. So let's say that broker gets 6% commission to sell the property. This broker knows that 95% of the time, another broker has a buyer that's going to buy that house. Statistically, guys, 95% of the time, another broker brings the buyer for your listing. So in order to entice that broker, I'm going to offer a co-broke fee to the other broker. Let's say I keep 4% and offer them 2%. That means that when this brokerage company produces a buyer and we go to contract, they're going to earn 2% of the sales price, and my broker, the listing company, is going to keep 4% of the listing price, because we co-broke and share information and commissions with other brokers to help us sell houses. So technically, the seller's broker pays the buyer's broker the fee the buyer will earn from selling this listing. So I hope I answered your question, Ayana, about how the seller's broker pays the buyer's broker. Elise, if seller does not pay buyer's agent fee, can the buyers ask the commission for their agent be part of it? If the seller does not pay buyer's agent fee, can the buyers ask the commission for their agent to be part of a seller's assist? You got me there. I don't know what you're asking me. I'm confused about your question. Trinidad, please answer my question. I don't see a question, Trinidad. What's your question? Error is showing no, have to refresh. So the buyer never pays fees for brokers? Typically not. So Trinidad, what was your question? I never saw your question. If you asked while you were muted or moderated, it never shows up. I guess I had trouble determining who was the broker's fee payer. That word, what words would, I'm sorry, the brokerage fee payer. The seller pays the broker fee in this example that I'm showing. I heard that all the rules are in place because agents, what? I don't know about that, Trinidad. I mean, that's what you heard. I can't back that up with any facts. Can you give me statistics or a study that shows that, Trinidad? Please? And where do you get your information from? Trinidad? Robert, there's nothing wrong with our feed. It's your end that has the problem, not ours. I'm trying to understand. I wish I wait until the end of class. Can you explain it again? Can I explain what, Ayan? I'm sorry. Guys, try to understand. I deal in 1,000 questions, and when you ask partial questions or questions that relate to other questions, I get lost very easily. All right. I'm going to have to move on. I'm sorry. And Robert, you do have a problem. You're supposed to be viewing this in a Google format. If you're having trouble with that, then I don't know how to help you. All right, let's get back to the study, and you guys will need to fill in the information when you read it. All right. Now, this consumer information statement must be given to any and all potential buyers and sellers before any substantial talk of real estate ensues. What? No, I'm being very serious. The state of New Jersey requires that upon meeting a customer for the first time, an agent, salesperson, or broker is required to sit down with them and give them a consumer information statement before any talk of real estate ensues. Hi, thanks for coming in today. My name's Tim Jensen. How can I help you? Yes, we're looking to buy a house. Great, let's go in the conference room. We'll sit down, and by the way, here's a consumer information statement I'm asking you to read before we talk about real estate. In it, it explains the 4 agency relationships that brokers can have with potential clients. And when you're done, I'm just going to ask that you sign a copy attesting to the fact that I gave it to you, and we'll date it today's date. That's all. So before we talk about real estate, before I show property, before any contracts are signed, I must sit down with my potential client and have them sign, or at least look over a consumer information statement, and then sign a copy that I can retain proving that I showed them the information statement on a certain date. By the way, the consumer information statement is merely that. It's an information statement. It does not create agency relationship. Too many salespeople say, but look, it says on the second page that the buyers, or whoever they are, intend to work with me as a buyer's broker. Therefore, I create an agency. And no, it's a consumer information statement only. It does not create agency relationships, but it is required to be given to any and all potential clients before any substantial talk of real estate ensues. So now I can hear the questions. But Tim, what if I'm at a social gathering and someone comes up to me? I have to carry a stack of these around with me everywhere I go? And the answer is no, you don't. That happens quite often. When I was at the height of my productivity, I always wore and I worked for Remax at the time, my Remax name tag. And I'd go out to like ShopRite, do some shopping. And people would walk up to you and say, oh, you're in real estate, got a question. And one of the women came up to you and said, Oh, you're in that real estate, but oh yeah, how much is that house on 427 East Main Street? What do you think I'm doing? Well, before we can talk, we got to sit down and talk about consumer. No, I asked her a simple question. Are you personally looking for a house for yourself? No, I'm just curious. Oh, that house is $499. Can you believe the price? And we had a chit chat. What did I do? I qualified her then and there. Are you looking to buy for yourself? No. Then you're not a client or a potential client right now. Therefore, I don't have to do a consumer information statement. But if you say, yes, I'm very interested in that house, what I would do is then I would take out a piece of paper or my phone and turn to my calendar and say, would tomorrow morning or afternoon be better to get together with you so we can discuss this? Right now, I'm in my shopping mode, and it wouldn't be appropriate for us to start talking business in the middle of a busy shopping center. How about if we get together? Was tomorrow morning or afternoon better? And we'll set a time, and at that moment, when we first walk in and sit down with them, I'll produce this consumer information statement and we'll talk. So understand, guys, there is ways to do this properly, and by qualifying them with a quick question or two, I can find out if they're serious or not. If they're not, then answer their question. If they are, then make a time when you can sit down and do this consumer information business. It is required for all residential sales and rentals of more than 1 year. It is not required for any commercial properties being sold or rented. It's only for residential sales and rents. So now that you have a consumer information statement signed, then you can get to work. So we spent all morning talking about agency, brokerage, ethical considerations, how to create them. Now we have to find out how can we terminate an agency relationship. Well, death or incompetency or even bankruptcy, as the second to last bullet point says, will terminate an agency relationship. So the buyer, I just got a note from somebody that the buyer just died. Well, guess what? Your agency relationship's done. Or they were declared mentally incompetent. Your agency relationship is done. Or they just declared bankruptcy. Your agency relationship is done. You're not working with them anymore. Destruction or condemnation of the said property could terminate an agency relationship. I just got a listing in Mahwah. It's beautiful. It's 1.3 million, but this morning I woke up to a note from the highway department that they're claiming the property under condemnation for eminent domain. They're going to put a highway through there. Guess what? That property is condemned. It's no longer marketable, and my agency relationship with the seller is now terminated. Mutual agreement will end an agency relationship. So that buyer who signed that buyer's agency agreement could always go to that buyer's broker and say, would you please let me out? I'd like to pursue a purchasing with someone else. If they agree, then you mutually destroy the agreement. It's over. But if they say no, then you're still in it. The agent can renunciate the agreement. Who's the agent? The broker. Only the broker can terminate agency relationships. Salespeople cannot. Only the broker can. Or it's revoked by the principal. What does that mean? Well, there's a legal manner in which you can revoke an agency agreement, and you'll need an attorney's input to figure out how to do it. I'm not telling you how. It's not my job. But it can be done. Or by completion or fulfillment of the purpose. Mr. Seller, when we signed that listing agreement, that was 6 months ago, and we just closed on your property. Congratulations, we sold your property. By completing my objective of fulfilling that agency relationship, I sold the house. My agency relationship now is terminated. Or the time expired under my listing agreement, and now they went to list with somebody else. I have no claim to commission or anything anymore because it expired and ended the agency relationship. All right. So before I move on, any further questions about these consumer information statements or how to terminate agency relationships? A revocation by principal is the buyer trying to revoke the agreement from the seller. or the seller, I'm sorry, from the agent, or a seller revoking the listing agreement from the seller's broker. That's what revocation means. Can you go back a slide? No, guys, again, we don't go back. All this information is taken directly from your textbook. Do you mean a real estate attorney or an attorney? Anybody who's familiar with contracts, Jason. But when I'm talking about real estate matters, I'm talking about a competent real estate attorney. Anybody else with a question before we move on? Obviously, we're going into the afternoon session with the rest of this chapter. Is there a standard for length of listing agreement? John, I can't say yes. I can't say there's a standard. However, most brokers will insist that you go out and get a 6-month listing minimally. How about if we just leave it at that? Is there a, okay, cool. Okay, anybody else? I don't see it. Oh, Arcibel, did you have a question? No? Okay, let's moderate. I got 10 minutes left before we take our lunch break and our admin staff comes online to answer your questions. So let's see what we can get under the belts by now. Buyer as principal. So the buyer's hiring you, the buyer's agent, to help them find a house. You would enter into an agency agreement, have them sign a buyer's agency agreement. And remember, because it's usually the seller who pays, whoever pays the fee is not the person who creates the agency agreement. I can work for a buyer and be paid by the seller. It happens all the time. So it doesn't matter who pays the fee, it's who I'm working for. Now, buying as you being a buyer's agent, I can ask the buyer to give me a retainer or a flat fee that I could use as security to make sure that that buyer is going to be loyal to me. And I would tell them, if you give me a retainer or a flat fee, I'll apply it towards the income I earn from the seller, and you'll get it back at closing. That way, everybody makes out and everything's cool. Or I'll just get paid a listing fee by the split I get from the seller's broker through my broker. So that's how we get paid. So there's many different ways to do work, guys. Your broker will train you on what he wants you to do. Now, we also brought up the specter of disclosed dual agency, and we went over this yesterday, but let's just repeat the steps. A dual disclosed agency is someone who represents both the buyer and seller in the same transaction at the same time. So if I'm working for a seller and I have a buyer for the seller's house, and if they both agree by signing consent forms, then I can work as a disclosed dual agent for buyer and seller in the same transaction at the same time. Perfectly legal if we disclose and have signed consent forms from all parties involved. However, Mr. Seller and Mr. Buyer, I can no longer offer the highest level of loyalty that a true seller's agent or a true buyer's agent would give. Because remember, since I'm representing both, I have to be equal and fair with both. I can't favor one over the other. So, Mr. Buyer, you want to know what kind of offer to write up? I'm going to tell you this. I listed the property through a negotiating with the seller by presenting a CMA on the property, comparative market analysis. I'm going to share with you that same CMA so you can see where the value proposition has been created. In other words, whatever information I gave to the seller, now I'm giving to that buyer. Whatever information I get from one goes to the other. Whatever information I get from the other goes to this one. And I can't be selective in what information. It must be completely transparent. I'm not working for the seller. I'm not working for the buyer. I'm working for both in the same transaction, but I cannot favor either one. And beware of the appearance of conflict of interest. Working with buyers, sometimes you become chummy with them and pally and all that kind of, soft and feely, And you may find a certain loyalty to someone. Well, that's when you have to take a switch in your mind and cut off your emotions. Because no longer can you be touchy-feely, pally with these people. It's all business. Has to be. You have to remove yourself in a way that makes you a neutral party. So a dual disclosed agent is perfectly legit in New Jersey, but you must have the consent form signed by all parties involved. Dual agency in New Jersey is legal if the broker discloses all legal duties that will and will not be available to the agent or from the agent, and any other business relationship that might affect the proposed transaction. Must obtain buyers and sellers' written informed consent to the brokers acting as dual agents, and advise each party that they may want to consult an attorney, again, using the competent real estate attorney here. Why? Because the attorney can advise them of their legal rights when I'm doing this. Very important that I disclose and suggest all these things in a disclosed dual agency. Conflicts of interest. When you identify with buyers or sellers, you furnish encouraging advice or assistance to either one. Negotiating and compromising, no. Guys, don't do this. Remember, you're a neutral third party just trying to bring a deal together. You're not working for one or the other. You're working for both. And if the deal falls through, it's quite possible that one of those parties may feel that you didn't do your job the right way and may try to sue you. Well, if you've done everything right, you don't have to worry about lawsuits. Your broker will protect you. If they claim damages, well, guess what? Your broker is going to say, go away. Your charges are baseless unless they have cause. If you didn't act neutrally, then you could stand a very high degree of loss of license and at least commissions or something else. So understand, guys, a disclosed dual agency must be that, disclosed. It cannot be undisclosed. A secret double agent. Can't do that. That's illegal, it's unethical, and you'll lose your license if you try to do it and get caught. Just so you know. So, disclosure issues, we talked about material defects. What about things that I can't figure out by looking at them? Latent defects. Well, that's why, Mr. Buyer, it's recommended that if we can't see the problem or know about it, it's recommended you get a home inspector or some sort of engineer or something to do an inspection of the property to find out about these things if the seller doesn't know. And I don't know. But if it's clear that there's an issue, then disclose the issue. But what about if the septic system's not working? I wouldn't know about it by looking at it. Unless I can smell an issue, I wouldn't know that the septic system's not working properly. And what about unused or oil tanks or underground storage tanks on a property? Mr. Seller, do you have any? Well, not that I'm aware of, but do you have any? I don't know. Well, Mr. Buyer, the seller says he doesn't know, so maybe we should have an underground oil tank or underground storage tank inspection. You hire an inspector, comes out with a metal detector, and he sweeps the ground. If he finds something, then there's something there. If he doesn't, then there's nothing there. So, Mr. Buyer, you always have the option to hire an inspection company to come in and inspect the property to find out any issues that we're not aware of. Also, Mr. Seller, did you have any damage loss because of an accident in the past? And if so, can we look at your CLUE reports, your comprehensive loss underwriting exchange report from your insurance company? That keeps a running record of all claims against that property for insurance purposes. So if we see that, we can give that to a buyer and they would have a better understanding of the property, if they have one. Off-site conditions are important to disclose as well. Because what if there's a new, school system going in? How would that affect this property over here? Your taxes are going to go up because of it. That could affect the material value of the property. So just because something isn't on site doesn't mean it doesn't affect the value. Now, we talked about Megan's Law. The last topic I'm going to discuss about is new construction notice. And the law is this: if you're selling new construction, your buyer may have an extra 5 days in which to rescind their contract if they discover an off-site condition that would affect their knowledge or their wanting to buy this property. They get an extra 5 days to cancel under new construction law. But if it's a resale, they don't get that extra 5 days. That's it. All right, it's 12 o'clock. It's time for our lunch break. I'm opening up the conversation because Lauren or Noel will be jumping online the next minute or two to answer all your admin questions. So at 1 o'clock, I will rejoin you. But in the meantime, hang on. They'll be online the next minute or so and answer your questions. So I'll see you at 1.